Good morning. Welcome. Welcome to all our Work Law subscribers and the guests of Work Law subscribers. You are extremely welcome. Nice to have you with us. On my left is Alan Rycroft. Those of you who don't know me, I'm Bruce Robertson. And we'll be taking you through the material over the next hour or so. The PowerPoint and a recording of the webinar will be made available on the Work Law site. We'll put it up over the next week, so you don't have to take notes. It will be available to you on the site. We plan to speak for about an hour, 75 minutes perhaps, and then we'll take questions and deal with your questions then. Please use the Q&A function at the bottom of the screen to ask your questions, and we'll answer them at the end of the input that we're going to provide. Alan and I are going to chat to you about two broad themes. Firstly, key factors in evidence if you ever have to prove or challenge the fairness of a dismissal arising out of compulsory vaccines at the workplace. And we've got some, I think, quite interesting and important themes there to discuss with you. And then secondly, we'll go on and discuss the landmark judgments from the previous year. Just on the first topic, this is not the forum to discuss the science of vaccines. There are different views, we accept that, but the overwhelming view is that vaccines are a necessary tool to deal with COVID-19. And in any event, mandatory vaccination policies have now been provided for in our legislation, and we are having to deal with that. So that's going to be the approach that we're going to adopt. Things may change. The science may change. Company policies may have to change. We're dealing with a moving target. Alan, any comments on that?
No, I think that's right. We just, I think, got to react according to the scientific knowledge that's available.
Yeah. Okay, I'm going to start by looking at two CCMA judgments that have come through. There are apparently over 100 cases which have been referred to the CCMA. There are no, as yet, court judgments, but there are two CCMA awards. So I'm going to share screen. The first one is the Gold Rush case. It deals with unfair dismissal. This was a training officer. She was employed in this company. She refused to accept the vaccine. She was identified as a high-risk individual by the company. She interacted daily with others, and she was identified as a high-risk individual. Her defense was based on the constitutional right to bodily integrity under the Constitution. She applied for an exemption. Her exemption was turned down, and she was ultimately dismissed for not having the vaccine. This went to the CCMA, and it's interesting, the arbitrator, in his judgment, it's quite interesting, he referred to a judge's memo that had been submitted to him, where the judge balanced the rights of the parties, and it's effectively in terms of section 36 of the Constitution. But this was just a memo where he spoke about the interests of the community trumping an individual's preferences. And I think that was just like a common language way of describing the balancing of rights under section 36 of the Constitution. So the arbitrator found that this employee had been permanently incapacitated. They had tried to look for alternative jobs for her. She was a training officer. There weren't any other alternative posts which did not require her to have the vaccine. And the arbitrator found that her dismissal for incapacity, that's an important point which you'll come back to later, that was found to be fair. So that's very simply and broadly, I'm moving quite quickly, but an outline of what happened in the one judgment, in the first award. In the second one, this Indaka security matter, this is an unfair labor practice matter. In this case, this employee was a safety officer. He was employed by a private security firm at Sasol. They required 100% vaccines amongst all their service providers, and he refused to have the vaccine. He was then suspended on full pay. There was some legal debate about whether keeping him away from work on full pay constituted a suspension or not, but the arbitrator found that it did. And the arbitrator said this was a reasonably practical measure to ensure a healthy and safe working environment under the Occupational Health and Safety Act, and that his suspension did not constitute an unfair labor practice. So, I mean, I'm moving quickly because we don't want to look at the too much, get bogged down in these two cases. They're the first with perhaps many to come. But certainly in these first two cases, both of them have upheld effectively the employer's mandatory vaccination policies. But we think these cases, in as much as they are pro and anti views on vaccines, we think they're going to depend very much on the facts of each case.
Yeah, and I think there's a feeling amongst most of us that COVID's over. And why are Bruce and Alan worrying about this? Well, I think the authority from the medical experts is that there will be another wave at the end of April. And there's no certainty whether it's going to be a milder than Omicron variant or a more serious variant.
So all of you can phone Alan in May and say if there's no fifth wave, phone him and say, well, where's the fifth wave?
So I think in case you're sitting there thinking, surely this is no longer relevant, we're walking around without masks and it's not necessary. I think that this is going to be in our lives for still some time. And I think what we want to move on to is 5 major points which we've identified as where evidence will be needed if a mandatory vaccination policy is challenged, either by union or by employees. And here are the 5 points. The first one is there compliance with legislative procedures. We're going to come to each of these 5 points in greater detail, but we think that's the first thing that an employer must be able to need evidence about, that they have followed what the different bits of legislation require. Secondly, can the employer justify those employees required to vaccinate? We'll see in a moment the choices available. The third point is how the employer dealt with the employee's reasons for refusal, how it was handled. The fourth area of evidence is, did the employer attempt to reasonably accommodate objecting employees?
That's an important one.
Yeah. And then fifthly, how were the dismissals categorized? When Bruce talked about the earlier cases, it was just one dismissal, and that was characterized as incapacity. We're going to come to that. So this is what we think we're going to spend about 10 more minutes on, just so that you can be aware of what legislation, what evidence is required if there's litigation on this.
Yeah, on the first point, did the employer comply with legislative procedures? There's a very detailed process laid down in the health and safety measures that were published last June, and in particular importance is Annex C to those health and safety measures. They're all on the WorkLaw site. You can access them there. Those of you who are not subscribers, you don't need a password. That stuff's for free. It's not ours. So it's important. And we haven't really got time to go in depth with this too much, but in summary, the employer's got to firstly undertake a risk assessment. Now, you've probably done that previously when we first got into the COVID era, but you would have to update your risk assessment to identify those employees that you believe require to have a vaccine. Secondly, then you've got to develop a plan as to how you're going to go about implementing this. And you've got to consult on that plan, consult with your employees, with your unions, provide info, and there's specified info that you have to provide. You've got to look at the detail there under the health and safety measures. And you've got to make the plan available for inspection by health and safety officers, by employees, their unions, etc. You've got to give paid time off for employees to go and get the vaccine. And you've got to, if reasonably practicable, provide transport for employees to go to these vaccine sites. You've got to deal with the side effects, if there are any. It says you've got to provide sick leave under the BCA, even if the employee's sick leave has expired. It then is a bit puzzling. It says, or lodge a claim under QUABA. I mean, I would say this would be and, but you've perhaps have to then do both. I'm sorry. Something popped up on the screen that we've been muted. I don't know how long we've been muted for. My phone hasn't been ringing, so hopefully that was something that just happened. But I hope you can hear us now, and that this is not the first time you've heard us during this webinar, but let's continue. I was saying, if there's a refusal to accept the vaccine, you've got to counsel the employee. Allow the employee to obtain advice from his or her union and other employees at the workplace. If there was a medical reason for refusal, you've got to pursue the option of further medical evaluation in an attempt to deal with those issues. And then you've got to reasonably accommodate employees who refuse the vaccine. So there's a clear process there laid down. And what's clear from the two awards which I mentioned just now is that in both those awards, the arbitrator looked very closely at the extent to which the employer had complied with this process. So as an employer, if you have to defend a dismissal, the first thing you'd have to do is lead evidence very clearly about what steps you went through and the measures you put in place. Just to also mention one thing, under the health and safety measures, there's a 3-week limitation period mentioned there, where the employer had to implement mandatory vaccination within 3 weeks of the Gazette coming into effect. Now, I don't think a single employer complied with that, and there are many employers who've gone this route thereafter. It wasn't mentioned in either of those awards, and it seems that that aspect has largely been ignored, but I do mention it because it is there in the background. All right, Alan, moving on to the next point.
So the second area where you might need to need evidence is, what kind of justification does the employer have for those employees who were or are required to vaccinate? And I think the first point to make is about choices. Some employers have gone the route of the across the board, as it were, vaccination requirements, and often on the basis that it makes no sense to do anything but besides that. But other employers have chosen to be far more selective based on a risk assessment. Our feeling, we probably think that it's easier to justify a selective one, although many employers have said to us it makes no sense when employees are sharing facilities like tea rooms and toilets and walking past each other in the corridors.
Entering in the same gate.
Yeah. So that's the first thing, the choices. And the second thing is the legislative justifications. The first legislative justification is the risk of transmission. And that in the case that Bruce referred to, well, remember there was a training officer would have to work in a closed environment with other people. That's a good example of that. That was a higher risk because of the kind of work. And then secondly, the employee's own risk because of their own health status and comorbidities.
Yeah. So however you're doing it, Alan, I suppose the bottom line is the employer has to be able to justify who it's applied this policy to.
Yeah, and I think it's going to vary entirely by what kind of place of employment it is.
Yeah. Okay, moving on. How the employer dealt with employees' reasons for refusal. it would seem that some employers have gone to great lengths to set up exemption committees and panels to evaluate employees' reasons for a refusal. And this may help. It may solve a lot of problems. I mean, you may have an employee, thinking of examples, a long-distance transport driver. He doesn't interact with anybody. He picks up his vehicle. He sleeps in the cab. He has no interaction at all with other employees. He's no safety risk to anyone else. Or a security guard who reports on duty with an electronic machine, and he patrols the outer boundary of a premises where he has to electronically register his appearance at certain places. He deals with nobody, and that employee may say, well, there's no reason why I have to have the vaccine, and maybe that would serve that purpose. But where an exemption committee or a member of management in a plant has to assess the moral reasons or the faith-based reasons that an employee puts forward, how do they do this? How do they assess whether someone's faith-based views are reasonable or not reasonable? I mean, I think it's going to be you putting that person or that group of managers into a very awkward situation. And I know some employers, and I mean, Old Mutual, for example, at the end of last year was in the press. It was said that they assessed the reasonableness of employees' reasons, and if they were not reasonable, they were given 5 days to either get a vaccine or they would be dismissed. They're obviously treating it then as misconduct, a refusal to obey a reasonable instruction, and that they are regarding as misconduct. So we don't advocate going that route. The first, as I've said, is to explore the reasons and to respond according to what you assess the reasonableness of the employee's justification to be or otherwise. We think a better way is for the employer to attempt to accommodate all objecting employees. Don't go into, other than the examples I gave you, where a driver or a security guard who patrols the outside fence, but we're saying a better approach is to don't get overly into evaluating the reasonableness of employees' reasons. Because even if an employee you think may have a good reason, it's not justification to allow him or her to enter the workplace and pose a safety risk to other employees. So a better approach, we think, is to then just attempt to accommodate in alternative ways all objecting employees if you can.
So the fourth area, which might become under scrutiny and evidence will have to be led, is what kind of reasonable accommodation was made. And it can vary entirely. It could be working off-site, it could be working at home, it could be in isolation. So there's alternative ways of doing work could be part of this accommodation. And it's defined in the Annexure C, means any modification or adjustment to a job or working environment that would allow the objecting employee to remain in employment, and then it gives examples. But I want to say that rather strangely, this Annexure C makes reference to the Code of Good Practice on disability. And when we first came across this, we weren't quite sure why, but it became very clear that this disability code introduces the idea that there might be some accommodation which it just imposes an unjustifiable hardship on the employer. It could be significant or difficult to do, or could be expense, and the employer would be justified in not offering any kind of accommodation. And in fact, the code goes on to say that maybe dismissal could be a solution as a last resort.
I mean, that's an interesting point, the last point that Alan raises there, because I don't think it's been picked up very often, that in fact this Annexure C, by virtue of incorporating this code, does provide for dismissal as a last resort. So that would be something that if you're leading evidence on in an arbitration as an employer to defend these types of matters, I mean, I think it would be important to raise these points at an appropriate stage. And the last point then is how are dismissals dealt with if that's what it ends up being. If no alternatives can be found, if you've explored everything and you have to go, you think the dismissal route, how are you going to describe that? Well, as you know, under the Act, there are three options, and those are the three. We don't think it's misconduct because of the constitutional rights that exist in this circumstance. We do not advocate going the misconduct route. And the Gold Rush case, which we mentioned earlier, dealt with it as incapacity. And we think that's the correct approach to adopt, because in the same way that an employee who's employed to drive vehicles doesn't have a driving license, doesn't have the capability of doing the job. Similarly here, if you have implemented mandatory vaccines, and that's now a requirement to not pose health and safety risks to other employees, people who do not fulfill those requirements have not got the capabilities of doing that particular job. Some commentators prefer the operational requirements route, and I think that there's an argument that can be made in favor of that. But whichever route that you go, make sure you comply with the Act and those procedures and processes which are ring-fenced under the different headings, and make sure you comply with the applicable code of good practice. Now, as you know, if you're going to deal with it as an operational requirements matter, you would have to consult under section 189, you'd have to give notice, written notice under section 189.3, you would have to consider the question of severance pay as an option, and decide whether are you going to use that section that says if there's you've been offered a reasonable alternative job, there's no obligation to pay severance. Are you going to use that as a vehicle not to offer severance, or are you going to take it on the chin and just offer these employees severance who, if you treated it as an operational requirements matter? Yeah, so those are the options to you, and we've made it clear, I think, what option that we would propose to, and that is the route that was taken in the Gold Rush case. Just one important point there. By changing the terms and conditions of employment, this is probably a unilateral change to terms and conditions of employment. So that's an aspect that would have to be dealt with perhaps. And you've got to be careful that these dismissals are not described as an automatically unfair dismissal. As you know, section 187, which defines automatically unfair dismissals, talks about under paragraph 1C, a refusal, it's automatically unfair to dismiss for refusing to accept a demand in respect of a matter of mutual interest. So if it was described that, well, I had refused to accept your demand that I have the vaccine, and I'm therefore being dismissed, that's automatically unfair. Not so. There's a subtle but important distinction. You are being dismissed because you haven't got the capacity to do the job. And I think it's similar to those retrenchment judgments, Fry Metals and others, where that distinction was recognized by our courts, by our Labour Appeal Court, and so on, where you are retrenched because you now haven't got the capacity under the new operational requirements of the employer, as opposed to refusing to accept the changes that new operational structure required. It's an important distinction, but it's a fairly subtle one. Any comments there, Al?
No, I think that's great.
So I mean, we've moved quite fast. Those are the key points that I think you would have to lead evidence on if you end up becoming involved in dismissals over these issues. And we think those are the key aspects that would have to be led in evidence either by employees and their unions to dispute it, or by the employer to substantiate the fairness of any action that you've taken. Just again to make the point, this is a moving target. The science may change, and we've got to ensure that we're not fixed in our views, that our views are science-based and that they continue to be science-based. And if the science changes, our views must change. And these things might move fairly fast. You gave the example of Austria to me yesterday. Do you want to mention that?
Yeah, well, I have two sons living in Austria, so I follow Austrian affairs quite closely. And Austria decided, I think it's the only nation in the EU that decided to make vaccination mandatory for the entire population. And this was obviously a very unusual decision. And yesterday they decided they were not going to implement. And we don't know why they decided to back away. Maybe the initial law was the nudge for people who were sitting on the fence. But anyway, things have obviously changed in a way that they can now back off enforcing mandatory vaccination for the entire country.
Also, just to mention, most universities in the country have gone this route, but we hear they've also stepped back from enforcing this.
Yeah.
Have you heard that?
Well, there's threatened litigation by student organizations, and I think because Omicron was a sort of less serious variant, I think the university might feel they don't need to enforce it. Yeah.
All right, let's move on. Enough on that topic. Let's look at some of the landmark judgments from the previous year and draw out what learnings we can draw from those judgments. Alan, you kick off.
I'm kicking off on a case on fixed-term contracts. As you know, fixed-term contracts are preferred by many employers for a variety of reasons. And whenever we asked about fixed-term contracts, our response is fairly standard. There's a famous Buthelezi case which said a fixed-term contract runs until the final date or the completion of the event, which was the reason for the fixed-term contract. And if an employer wants to retrench in the fixed-term contract period, it cannot do so. The employer has chosen the form of contract, it must bear the risk of anything happening during the contract. And they must basically pay the employee out until the end of that contract.
And that was a Labour Appeal Court judgment, wasn't it?
I think so.
Yeah.
So that's been our advice, and it's been fairly standard, and it's been sustained by the courts for quite consistently. Then suddenly there's been a case where an architect was employed on a 5-year fixed-term contract in the construction of the Four Ways Mall project, whatever that is, and 3 years into the contract, he is notified that he's got to be retrenched. And his initial response was, I'm protected for 5 years. And he had sort of ordered his entire life where he lived and so on the assumption of 5 years. The contract was an unusual one, and it allowed for, it said the duration was until suspension, termination, or completion of the Four Ways project and any related work. And it allowed for termination on a one calendar month's notice. So you have a strange hybrid, and the court has accepted that there is you have a fixed-term contract, you have the indefinite contract, and now it seems they're acknowledging that there's a hybrid contract where the employer can end the contract prematurely. So here's the basic principle in this case. There's no right to terminate a fixed-term contract prematurely unless expressly provided for in that contract.
So I suppose the learning there for employers is that if you want to retain this option, you've got to look very carefully at the wording that you use, because the answer lies in the wording of the contract.
Absolutely. Now, I wanted to say this case had a second principle. There's a principle called bumping, which is not often talked about, but it's a principle in retrenchment law, which allows an employee who's been selected for retrenchment, if they have been there for a longer service, to bump somebody who hasn't been chosen for retrenchment. And the idea is that it's to respect seniority. Now, the architect in this case believed his dismissal was also unfair because he wasn't allowed to bump another architect out who had been employed for a shorter period. But the employer defended keeping this other architect because that person was, in a specific way, better connected to the client and the contract in different ways. And so this case also upheld the second principle that bumping, subject to factors such as skill, compatibility, and client contacts, particularly at senior management level. So bumping is allowed, but it is subject to these other factors.
Yeah, so I suppose the learning there is that bumping is not just a question of looking at length of service, particularly in those higher grades.
No, so one feels very sorry for this architect. He's a professional person.
Yeah.
He felt he deserved to be treated for the full, employed for the full 5 years. So as Bruce said earlier, it's really important to read the fixed term contract to see, in fact, is there any risk?
Yeah. All right, moving on. Our next judgment is a Labour Court judgment, and it deals with the tendency for particularly senior management employees to dash off to the court to try and interfere or halt a disciplinary process when it's been implemented against them. In this case, this person was employed by the post office. She was ill on a regular basis, which just happened to coincide with the dates of her inquiry. It was adjourned again and again and again. And eventually when the employer, the post office, said, well, they're going ahead, she rushed off to the Labour Court to try and halt the process on an urgent basis. And I mean, it's an interesting judgment. If you're in the habit of bedside reading and you read Labour Court judgments, you will know that they set out the facts and then they analyze the facts. And in this case, the judge was on a mission, and he kicked off first page with saying this is a really unfortunate tendency. He referred to a previous Labour Appeal Court judgment that had said that there was jurisdiction for the court to interfere, but only in exceptional circumstances. And he said this was now time to draw a line in the sand. We can't have the Labour courts having to deal with these cases all the time. And he made the point, and I'm going to screen share. He made the court that the Labour Court is not there to micromanage the workplace at all, and it should only intervene in exceptional circumstances. So he granted a costs order against this senior manager for bringing the urgent application, and he turned it down and said urgency will only be allowed when it's not self-created, and in this case, and the applicant hadn't acted timeously, and the urgency was effectively self-created by the applicant in how they had dealt with the matter. And there was real prejudice that would have occasioned to the post office had this been granted. So I think the learning here is for those senior managers, be extremely careful before you now take advice from your lawyers and dash off in the Labour Court to try and halt the disciplinary process. You may well have it turned down, and you may well have a costs order granted against you.
Yeah, the phrases that the court used in that judgment were interesting. It is very important. It said that workplace discipline remains a managerial prerogative, and the court said we will not intervene in that process.
And they're also saying there are avenues under the Labour Relations Act. If you ultimately are unfairly dismissed, take your case under the dispute mechanisms which exist in the Act. So if it's unfair, well, then you have recourse.
Yeah. So our next case is also in the area of unfair dismissal. And I'll start with these questions. What happens if the charge that the employer uses is that the employee stole or sold the employer's property? But in fact, what happened was an attempted sale, attempted theft. Does the person walk away because the charges, the way the employer described them, can't be proved? Or do you step back and say, hang on, they were involved in misconduct. There's evidence that they did take some property, they did try to sell it. So those were basically the facts in this case, the Sol Plaatje municipality case. A manager instructed a supervisor and his team to fix a roof. The next thing, they were removing an air conditioner, and they were clearly on their way. They were caught on the way to a secondhand shop to sell this thing, and they were stopped in their tracks. And so that stopping in the tracks became where the theft and the sale were stopped. And initially at the bargaining council and in the labour courts, it was found that because the employer couldn't prove the actual charge that you stole and that you sold, that in fact they had to be found not guilty. But fortunately, I think sense prevailed in the Labour Appeal Court. And what the Labour Appeal Court said was more focused on was that there was misconduct generally. And basically saying that if you charge somebody for, that is the first point I should say, they said you must really avoid an unduly technical approach to framing the disciplinary charges. So when Bruce and I are asked how to we frame a disciplinary charge, we always usually say you are charged with misconduct, in that it's misconduct you're charging them for, rather than a very specific criminal law approach. But in this case, went on to say that even though you might have been charged for a serious charge like theft or attempt or selling the employer's property, you can be found guilty of an attempted lesser charge. So like you could be found guilty of attempted theft. So you don't have to have a separate charge. So the court is saying, let's not be like the criminal courts, where you stand or fall on evidence on that explicit charge. It allows you to step back and say, look, has this employee been involved in misconduct, and can they be found guilty of a lesser charge? They might not have been found guilty of theft, but there was attempted theft.
And then is it fair to say that, this is a trend that if you look at the Avril Elizabeth Holmes case, which is now quite an old case, but don't adopt a criminal law approach.
Yeah.
Look at basic elements of fairness. Have the issues been canvassed in some form of inquiry? Has the employee been allowed to have their say in response to allegations? And has there been misconduct which has been proved?
Yeah.
I think it's a much more sensible approach, I think, that's coming through in these judgments.
Yeah, that's it. In fact, the Labour Appeal Court has fairly consistently said we are not a criminal court. Employers can take a far more informal approach to discipline.
Yeah. Let's move on. Let's deal with provocation in assault cases. And often in assault cases, this comes up as a defense. I was provoked. Alan does it to me every day. And you can assess whether my response is going to be justifiable or reasonable or not.
It's the only way to get them to do things.
Good help is hard to come by. In this case, there was a heated altercation between a manager and a supervisor. The manager was severely provoked by the supervisor. He was saying things like, hit me, go on, hit me, which the manager then did. He hit it. He was ultimately dismissed, and it was found at the CCMA that the dismissal was too harsh a sanction due to the provocation which had occurred. This matter got before the Labour Court, and I think this is an important judgment. And they said, did the provocation justify the response that resulted from the manager? And they said, no, it didn't. He was given a chance to walk away. An HR person stepped in this case, and the manager could easily have walked away, and he didn't have to, in a sense, assault the employee in response to what had occurred. So the principle that emerges from this judgment, it's a NAMPAC case, provocation bounces in there, and would it have caused a reasonable person in that position to have responded in that way? So it's got to be in proportion to the provocation in order to be an adequate defense to a charge of assault. Any comments on that?
No, I think that's a pretty sensible thing, because in most assault, the defense is I was provoked.
Yeah.
Shall I move on?
Yeah, let's move on.
I think one of the most radical innovations when the Labour Relations Act was introduced in 1995 was the idea that reinstatement was the default remedy if it was found that dismissal was unfair. that was done for very deliberate reasons. It wanted to make sure that employers didn't dismiss at will, knowing that the person would never come back. And so reinstatement is the default remedy. And the Section 193 of the Labour Relations Act gives 4 situations where reinstatement doesn't have to take place. One, where the employee doesn't want, him or herself doesn't want to go back in. Secondly, where it's intolerable if the employee gets back reinstated. Thirdly, where it's not reasonably practicable. And fourthly, where the dismissal is only because there was found to be unfair, only because the procedure was unfair. Now, in the last year, there have been 4 cases, 3 Labour Appeal Court decisions and 1 Constitutional Court decision, all on this issue about when reinstatement must be ordered or may not be ordered. And we are not going to give you the details of all 4 cases will be in the attachments that you receive after this webinar. I'm going to just briefly describe the different approaches, but I'm going to end up with the Constitutional Court case, which we will put a slide up eventually. In the first Labour Appeal Court case, it was a question of whether a person, this was a chef working in the police service, not as an active policeman, but nevertheless working for the police, could be associated with an immoral lifestyle. This person had been charged for rape of a 16-year-old woman and dismissed. But then when it got to the bargaining council, it was found that in fact it was consensual, this relationship, but nevertheless it was touched with scandal, and the police refused to reinstate, and that became the issue of whether or not an employer was entitled to use what they would call the ethos of the police to justify that it was intolerable to allow this person to be reinstated. When it's got to the Labour Appeal Court, and also it was pointed out the police did not lead specific evidence about why it was intolerable. The Labour Appeal Court said, nevertheless, the court was entitled to look at the dominant consideration was fairness, and they assessed that it was fair that reinstatement was not granted. Okay, so that was the first case.
And that was the Labour Appeal Court case.
All the cases I'm going to mention are Labour Appeal Court cases. The second one was a banking case. That's important because an employee who was a custodian in the bank's treasury department was seen to be taking some money out of one of the bank boxes, but he wasn't searched, and so there was no proof of the theft. But his behavior before and after the event were enough to really trouble the bank and affect the trustworthiness of this person. And the question was whether that behavior, which there was evidence about his behavior before the theft and what he was seen doing, and then after the theft, was enough to say that even though he was found not guilty of theft, to justify that the reinstatement is intolerable, the Labour Appeal Court in that case said it was sufficient, that there was this evidence about that behaviour.
Yeah, I mean, I really question that judgment, because if there was evidence of that type of behaviour, then surely it goes to a breakdown of trust, which goes to whether the dismissal was fair in the first place. But anyway, I think there's an overlap there, and perhaps that Concord judgment, which you referred to just now, might have been a useful one to have been dealt with if that had come through before that Labour Appeal Court judgment.
Absolutely. The third case is another Labour Appeal Court decision, VSB Construction, where a very traditional line was taken. Unless there's exceptional evidence that the relationship has become intolerable, reinstatement must be granted. So it was a straight conventional judgment. So we've finally come to the...
Shall I bring it up on the screen?
The Constitutional Court judgment. And it's the case of the Boy's case. And here, something rather surprising takes place. By tracking the history of this and how special this requirement is, that reinstatement is the default remedy, the Constitutional Court says the word intolerable doesn't reflect actually what the meaning behind it all was. And in fact, we've got to read the word intolerable to imply a level of unbearability. And so it requires that the relationship has got to become completely fraught. It can't just be difficult. So it's this very high threshold. It's more than just difficult. It's got to be fraught. It's got to be sour. And well, I've got some difficulties with this because when you think, the word intolerable is a very flexible word in the English language. It means a whole range of things. And I can understand why the Constitutional Court is putting it at the very high threshold, because you are stopping the reinstatement. But I think what's going to happen is that employers will start to simply use the term unbearable. They will replace the word intolerable with unbearable in their evidence and say it's become unbearable because I can't trust the person. And they would have, so I think not much is going to be achieved practically.
I mean, I suppose the learning to me is that you're going to have to go some as an employer to persuade the court in the light of this judgment that reinstatement should not be the default remedy for the unfair dismissal that you're dealing with. I think it's effectively raised the bar.
Correct. Yeah.
Yeah.
I think it's questioning, when you think about it, after a really messy, even violent strike, the strikers come back to work and the relationship is somehow restored or reformulated. You get on and work together. I think the Concord was really recognizing that it is possible for people to find a way forward.
Even if it's difficult.
Even if it's difficult. And even if it's, and in fact, we do know that from our personal experience, that we have to get on with difficult people.
Very difficult to work with him.
Exactly, but I mean, he manages. So I'm not yet unbearable.
Well, that's a subjective view. The extent, let's move on. There's another Constitutional Court judgment which I want to deal with. And it deals with the extent to which serious misconduct impacts on compensation for procedural unfairness. So there's been a dismissal, there was good reason to dismiss, but there was procedural fairness. To what extent does the seriousness and the magnitude of the misconduct that occurred potentially impact on the award of compensation for that procedural unfairness? In this case, there were 4 charges of sexual harassment against a doctor. He was head of department in the Department of Public Health, and it's alleged, and he was found guilty of sexually harassing an intern 30 years his junior. So this is a really serious case, 4 charges of sexual harassment. Interestingly, early on in the court process, before it got as far as the Constitutional Court, they even found the dismissal to be substantively unfair at one stage due to him not being treated in the same way as other employees in similar circumstances, which is fairly astonishing. But ultimately, this dispute ended up with an assessment over what compensation should be awarded for the procedural unfairness. And at arbitration, he was awarded nearly R1 million. So this is a doctor who sexually harassed an intern 30 years as junior on 4 occasions over a significant period, and he's going to walk away with over $1 million. This got to the Constitutional Court, and they said this. They said it's difficult to comprehend that the doctor could walk away with almost R1 million from a barren public purse. And they explored what issues should affect an award for compensation. Let me call it up on the screen. It's a case of McGregor versus Public Health Bargaining Council. One looks at the degree of unfairness. How unfair was the procedure that was adopted by the employer? What was the employee's attitude with regard to what happened? And they said, you most certainly can take into account the gravity of the misconduct. And they went as far as saying serious misconduct may actually even justify no compensation at all for procedural unfairness. So this is, I think, the important learning out of this judgment is for employers who are having to defend a potentially unfair process. There's been serious misconduct. You can use this Concord judgment to even argue that the court or the arbitrator should award no compensation at all. That was explored as an option in this case, but the court did go back and say, well, there had been unfairness, and they reduced the award of compensation from almost 6 months compensation down to 2 months. So they reduced it by a third. So he still walked away with a fair amount of money, but not as much as had been awarded by the arbitrator. I'm going to quickly deal with the next case before Alan moves on to some more complicated cases. But I'm going to deal with a case, it's again a Labour Appeal Court judgment, dealing with the concept that retrenchment consultation is a bilateral process. And this is not new, but it does affirm that principle. This case involved Ikapa Mining. They were seeking to retrench under Section 189. They consulted NUM. It was a process under Section 189A. A facilitator was appointed by the CCMA. They had at least 5 meetings. The person appointed then ultimately withdrew from the process, but he said it was going nowhere. They reached a stalemate, and the employer issued notices of termination ultimately. None then challenged the fairness of the process. And there was a dispute of fact over whether or not none had withdrawn at one point, and the Labour Appeal Court agreed that there was evidence that that none had actually withdrawn from the process. So the facts are not particularly important. They're messy, as many of these cases are. But the principle, again, and this is not something new, is that Section 189 is a bilateral process. The employees and the union are expected to contribute in this process. And if they frustrate the process, the employer is entitled to continue with the retrenchment. So the learning here is that the consultation under Section 189 is not a one-way street. It is a bilateral process.
So I want to change tack with the next case and to introduce it by saying that it's uncontroversial that there's a constitutional obligation on employers to make sure that the workplace is demographically representative. And I think that it's uncontroversial that there's an entire legislative plan of how this can be achieved. But I think that there's often under pressure or efficiency measures that in fact quotas have crept in as the basis on which to screen candidates for jobs. And this case describes one of those hard cases where an applicant, a white male, applies for a job, and this is his 4th application for a job, and he is on each occasion screened out without his application even being read. He was an acting magistrate, had been an acting magistrate for 4 years. You're not meant to be an acting magistrate for more than 2 years unless you are exceptional. And he had no difficulty in getting chief magistrates to confirm that he was exceptional. He ended up running a court which eventually was found to be the 15th best performing court in the country. And so he had this kind of flawless track record. And yet he wasn't even being considered at the first stage. And so he litigated against the Magistrates Commission, and this went all the way to the SCA. Maybe you could bring the slide up. I want to say that he went to the High Court. We can see that he went to the High Court first, which is unusual, but I think he was challenging the promotion regulations in the Magistrates Commission, and he chose the High Court. And then it went on to the Supreme Court of Appeals. But having said that, I want to say that the High Court found the Magistrates Commission's selection rules to be unconstitutional and unlawful. And so that's the issue. That's why it's the Magistrates Commission that became the appellant here. And the Supreme Court of Appeal found that the High Court was correct, that to use quotas at the shortlisting stage, in other words, that means, I must be explicit here, this judgment is about that initial stage, the shortlisting stage. You may not use a quota to eliminate any race group or gender just on those facts alone. You have got to, at the shortlisting stage, consider all applications. So at the shortlisting stage, legislation does not permit a targeted group approach. And I think, what else?
Second principle.
Yeah. So the process, which is rigid, inflexible, and quota-driven, with a blanket mechanistic exclusion of one group, is not permitted. I want to repeat again that this is not trying to undermine affirmative action. It's simply saying that at the shortlisting stage, quotas are not allowed.
Yeah.
I want to.
Well, quotas wouldn't be allowed at any stage.
No, but I think what's happening is that quotas are an easier way to work than targets.
Yeah.
I want to kind of, before we move on, Bruce.
Just get out of the slide.
Yeah, sure. On work law, there's a 2021 case called eThekwini Municipality versus Nardison, which I really recommend that you read in conjunction with the Lawrence case. And it's also a case about being fair in the application of affirmative action procedures. And it proposes a two-pronged test. Is the measure rational? And if there's a quota, it won't be rational. And then secondly, if it's not rational, you ask the second question, is it fair? And in fact, the judge in this case sets up some really useful questions. So that's the eThekwini Municipality versus Nardison case, which I'd like to recommend.
Okay, thanks, Tony. Difficult area. Let's move on. We're going to look at, to end off, and we've got about another, I think, 4 or 5 cases to deal with. We're going to look at strike law. Some of the advances over the last year or so in strike law. We're going to look at a number of factors. Firstly, who's involved? How do you determine if there's misconduct during a strike? How do you determine who's involved in that out of a big group of employees? Secondly, the cases deal with the EFF, but it's any party's involvement in labor matters. Is this allowed? Thirdly, a really difficult issue, rewards and penalties. For rewards for non-strikers, are they allowed? And can you penalize strikers for exercising a constitutional right to strike if they do it in terms of the mechanisms under the Labour Relations Act? And firstly, those really difficult situations where you faced with a strike demanding a manager be moved, dismissed, transferred. How do you deal with those? How has the court dealt with those?
So I'm going to kick off with this issue of how do you decide who's involved in misconduct in a strike situation? Here are the facts, rather unhappy facts of the case. The head of human resources goes out of his office to engage with employees. He's surrounded, assaulted, he's pushed out of a glass window. He had rocks thrown at him, punched, kicked when he lay on the ground, and he sustained a number of injuries to his face and his body. 2 employees who weren't on strike came and rescued him, and he was hospitalized. There were about 14 employees directly involved in that assault, but there was a much bigger crowd who were cheering in support, in fact, celebrating the event. The employer took action against 148 employees, all of whom were dismissed following a disciplinary inquiry chaired by an independent external chairperson. All the employees were found to have participated in an unprotected strike and acted, and here's the important words, acted with common purpose against that HR director. Now, how did they identify these people. That's because you've got 12, yes, those people, there was evidence about those, but how did you know that those 148 people were in a common purpose? They said that the employer said they had determined the identity of those people from their own photographic and video evidence, from clock cards used in the payroll system, which recorded all the employees who had come to work on that day. They had looked at job cards from particular workstations, and then they had used the evidence of witnesses. They'd also given all employees the opportunity, using Dropbox or WhatsApp, to send a message to explain that they were not there at that time and not involved. And no employees took advantage of that. So as I say, there was this group who were directly involved, and there was this larger group who were in support or in common purpose.
Shall I pull up the slide?
Yeah, please do.
This is this Marley Pike LAC judgment.
Correct. I want to then go to the principle developed by the Labour Appeal Court, that there is common purpose when the employee associated with the group, even if not present.
So they can associate afterwards if they've associated ex post facto.
They could come to that assault scene and join the singing.
Okay.
Yeah. They knew of the misconduct and held the necessary intention in relation to it. And here's the thing which I find very difficult to get my mind around. The employee must have foreseen the possibility of misconduct and yet associated with the group's actions. I think that's the hard thing to establish, Bruce. I don't know what you think. You know, you are striking, and you might be striking lawfully, and you are part of a crowd. You don't yourself think, oh, this could turn into a violent assault.
Yeah, look, I mean, I think these cases are very hard. They're very difficult, and I think the Labour Appeal Court here knew where it wanted to end up, and it was going to find a way how it was going to get there. And this principle of common purpose is a difficult concept, where employees are deemed to be associated with a group. All of us know how hard it is when there's a group of people who appear to have a common purpose, how difficult it is to not associate with the group if you're a part of that group. I think it's a very difficult issue. And there's also you want to comment on this recent constitutional court?
So in the last week, there's been a constitutional court decision known as the Oak Valley case, which we're going to be dealing with in our March newsletter. So you can watch out for that, where the constitutional court made a ruling exactly on this idea of how do you identify employees involved in criminal or violent activities. The context of the Oak Valley case was about interdicts. Now remember that an employer in seeking interdict has got to show a reasonable apprehension of harm. And what the Concord is saying, that it's just become too easy. You say, look, here the employees on strike, here's my harm, the harm that I'm going to suffer, and I fear that the whole group, and so the interdict applies to everybody. The Constitutional Court has made a ruling that there's got to be a link between the individual employee and this reasonable apprehension of harm. That's going to be hard, but the Constitutional Court, without even using the words common purpose, used the phrase, if the strikers are working as a cohesive group, that's the phrase they used, then it would be possible for the employer to seek an interdict against that cohesive group.
So if they were acting in common purpose. No.
Well, no, I think that's yes, I think there's a slight difference, but I think that I don't think that the previous case that we talked about, the Labour Appeal Court case, would have been held the same way if the Concord case had been decided first.
Okay.
I think it's going to change the law a little bit.
All right, we've got 3 judgments left, so hang in there if we're exhausting you. The next judgment deals with EFF approaching becoming involved in labor relations issues. And we've seen this tendency. We've also had business forums approaching employers on construction sites, and it's a real problem. And so I think it's important to comment on this judgment. This isn't the only judgment. There have been previous judgments which have adopted the same theme. In this case, the EFF approached a member of the SPA group, demanded a meeting. I think the employer at one stage agreed to meet and then said no, they weren't prepared to meet. The situation turned violent, and the employer went to court, labor court, to obtain an urgent order against the EFF. And this principle is not new, but it's important to restate it. Brightstone Trading versus the EFF. A political party can be held liable for the conduct of its members acting on its behalf. And in this case, the branch secretary of the EFF was deemed to have been acting on behalf of the EFF. And the court made it clear that the Labour Relations Act designates dealing with workplace issues and disputes to trade unions. This has no place for political parties. And they awarded a costs order against the EFF in this judgment. This was not the first cost order that's been granted against the EFF, but again, this is a very useful case for those employers to refer to who have to deal with this type of situation.
The next issue which we want to deal with under strikes is whether or not an employer can reward non-strikers. I suppose some of us might just say, well, hang on, isn't a strike part of the kind of like the battleground, and you can create whatever weapons you need to win that in that battle? But Section 5 of the Labour Relations Act prohibits discrimination, and it's a bit gently phrased. It isn't specific about what format discrimination against trade unions can take. And previous cases have been quite clear.
What it says, Alan, it says you can't discriminate against someone for exercising a right in terms of the Act.
Correct, yes.
It also says you can't provide an advantage to someone for not exercising a right under the Act.
So that was the basis of earlier cases.
Yeah.
So on one case, an employer gave a mere 200 Rand Christmas voucher to non-strikers. That was found to be unfair.
Won't get you far in this day.
No, it was an early case. It was, in terms of Section 5, was found to be unfair discrimination. In a subsequent case, in the Macro Sands case, there was something which would persuade Bruce to stay away from striking. They were given a Kentucky Fried Chicken pack every day, but plus also access to lots of overtime. So that was also found to be unfair. Now comes along a case where the employer beforehand, before the strike, says, look, if you go into the strike, the annual production bonus will be withdrawn. There's a 12-day strike, and the employer thereafter announces that the annual production bonus has been withdrawn for all employees, even those who were non-strikers. But the employer said, I am introducing an exceptional performance bonus, and this will be awarded to those people who helped the employer keep to 52% of production rates with only 34% of the workforce. Basically, the argument was these non-strikers worked exceptionally hard. And so the idea was that there was it didn't fall foul of Section 5 because the non-strikers were not advantaged for not exercising their right to strike. They were advantaged for their attendance and exceptional performance during the strike. But for the exceptional performance, the bonus would not have been paid, they said. So this case, the Cullinan Diamond Mine case, the Labour Relations Act does not explicitly prohibit rewards for extra work. Now, Bruce mentioned earlier, you can't advantage. You can realize we're playing with words, aren't we, to some extent. But bonus payments are permitted if the incentives are suitable and proportional. Non-strikers are not advantaged.
That's it.
And then you have those two requirements.
Yeah.
And you can see, well, surely a performance bonus is going to advantage you. But I think the court was saying they were advantaged because of extra work.
Yeah, look, and these are difficult cases. I mean, you've got this section under the section 5, I think it's subsection 3, that you can't promise an advantage for not exercising a right in terms of the Act. A protected strike is a right in terms of the Act, so you can't provide an advantage if you don't go on strike. The Act is pretty clear. So I think in this case, it may be yet another of those where the Labour Appeal Court was trying to find a way around this, and it got very close to, I think, recognizing that a strike is a power play, and you can use whatever economic weapons that you can to win the strike. So in the same way that you can use replacement labor, etc., maybe providing an incentive, but make sure, I think the learning for me is that the incentive would have to be linked to performance during the strike, as opposed to linked to the fact that you didn't go on the strike.
Well, I think that's what they were very anxious to make that distinction. The advantage was for exceptional performance.
Yeah.
Yeah.
All right, our last case, a tough issue to deal with, and this is also a Labour Appeal Court judgment. This is a sad tale of the CEO of an Eastern Cape hospital. When he arrived at the hospital, it was completely dysfunctional. It just wasn't working cohesively at all. And he sought to bring about improvements, to improve performance, introduce better systems, and to get the hospital back on its feet. Maybe he was a bit high-handed and overbearing in his approach. He was opposed by employees or many of the employees and their unions. And what ended up with being a 5-year sort of war between the CEO and in his attempts to get things right at the hospital, and the response from organized labor at the hospital. After 5 years, he was assaulted at one stage in the process, but after 5 years, the department forced him to accept a transfer and said this was in the public interest. It was in the public interest of patients at the hospital, of the staff, and of the surrounding community as well. And this went all the way, and he refused the transfer, and he was ultimately dismissed. This case has got as far as the Labour Appeal Court. It's Walsh versus the Eastern Cape Department of Health. And those of you who deal with these, and these are difficult circumstances to deal with, it would be useful to go and have a look at the judgment and read the sort of history behind it. I think you will get some useful points out of it. But ultimately, the Labour Appeal Court slated the lower court and the arbitrator, and it said that public interest cannot be defined in a way, as it was in this case by the Labour Court, to permit anarchy to be rewarded in the form of the public interest. And the Labour Appeal Court really slated the Department of Health and said they'd given in to the demands of unions, and they had capitulated to the unions in this case. So apparently the Department of Health has taken this on appeal to the Constitutional Court, so we haven't heard the end of this case, and we wait to see how the Constitutional Court deals with this judgment. But I'm hesitant to offer advice in these type of circumstances, but I think early interventions are important to attempt to address the management style of the CEO, if that's the person that's under the spotlight, and try and get some third-party intervention, which tries to agree a way forward between the parties. But I think the principle is clear that you cannot give in to mob rule in this type of circumstances. It's a slippery slope for the organization involved. All right, so those are the judgments we wanted to deal with. Just to end off, those of you who are not work-law subscribers, just to highlight our key services if you don't know much about us. You can access online all the case law that you need. We update our subscribers weekly and monthly. You can obtain advice via our helpline. We give advice via email on the same day. There are a number of books online effectively written by Alan on unfair labor practice, unfair dismissal, basic conditions, etc. Access all the legislation you want. There are model procedures, forms, and checklists available to you. We provide, in a pre-COVID area, we had live workshops, and we provide webinars. And there's a 3-day trial period which you can access. Just get hold of me. There's my email address. And we can let you have a look at Worklaw online and try it out for yourself if you want to. All right, so that's the end of our presentation. We hope, I see that we have still got a large number of people logged on, and we thank you for your patience, having sat through what's been an hour and a quarter. So well done. You deserve a medal, listening to Alan in particular for that length of time. But thank you for participating. Let's deal with any questions, and there aren't many. I think there appear to be a couple here. A question was asked about COVID. After attempting reasonable accommodation, can one thereafter dismiss an employee? I presume that's in the sense of in the COVID mandatory vaccine approach. And I think yes, I think that's what we are saying. That's been recognized in that Gold Rush case. It's recognized in the code that we refer to. And I think if you've led evidence on those 5 key areas which we outlined to you, I think you have every chance, in our view, that your dismissal will be found to be fair. All right, and then there's a second question. How does Fry Metals play a role in the potential categorization of incapacity? Complex question, that difficult legal question. Fry Metals and others, it was in a retrenchment, restructuring sort of environment, and the employer had attempted to agree changes that were necessary for operational purposes. Ultimately, those changes weren't agreed. So the employer said, well, fair enough, we can't persuade you. We can't force you to change your terms and conditions of employment. And we are now going to offer alternative employment to other people who are prepared to work under these circumstances. And so that then required them to implement a section 189 and to consult with the employees they currently had who didn't want to accept the changes about a possible retrenchment. And as we said when we discussed this, that you've got to be very careful that you're not being dismissed because you refuse to accept a demand to change your terms and conditions of employment. You're being retrenched because of the operational circumstances that require changed circumstances. And that distinction, I think, was recognized by the courts in those cases, Fry Metals and others. And I think a similar argument can be raised over COVID vaccines. Circumstances have changed. The operational requirements based on current science require people to be vaccinated. And there are those judgments which you'll find on Worklaw which say that employees cannot expect their terms and conditions to be cast in concrete from the time that they ever began employment till time immemorial. So different circumstances, changing circumstances do require change. So I think it was in that sense that I mentioned Fry Metals, and I think similar arguments could be raised as have been raised in the past in those circumstances. Do you want to comment?
So isn't the question asking, that's about, the question is about how does incapacity fit into Fry's Metals?
Yeah.
Because I think that was an operational requirements dismissal. I think Bruce was simply making the point that if you say, unless you get vaccinated, you're going to get dismissed, it falls into automatically unfair dismissal territory.
Yeah, I mean, I think similar arguments can be raised, even though those cases dealt with operational requirements, I think the same principles and theme would apply
Yeah.
in an incapacity circumstance. The question's been asked, you take on the employment of foreign nationals and the attempts from the Department of Labour in setting targets on the type of, our take on the employment of foreign nationals and the attempts from the Department of Labour in setting targets on the type of skills allowed to be offered in jobs for foreign nationals. Alan? He happens to be writing an article on this in the next newsletter. So those of you who are not subscribers, you better subscribe quickly because you'll get the next March newsletter.
So we don't yet know what these targets or limits are going to be. There's just been one really distressing case decided in the last week, which doesn't suggest that we've got a coherent policy yet, where a company that had plenty of clients overseas and needed German, Spanish, and French speakers to handle queries from clients, they came to court to say they wanted was to try to coerce the department to grant visas for people who had those language skills. And the court, although recognizing that the business, it was an operational requirement for the business to have German, Spanish, and French speakers to handle queries, despite recognizing that, said no, the employer's got to train up people in those languages, local people. It's a kind of really, I think, I don't know what,
I'm not following words for you. You can answer the
no,
question.
I'm not going to be too judgmental, but I want to say that I think the law is still very flexible and very fluid about what's going to happen. They've got to balance operational requirements with the obvious need for South Africans to get jobs. It's a very difficult tension.
Okay, but you are writing an article on this.
Yes. By the end of March, I hope to have formulated a clearer view.
Perhaps a more coherent view than you just expressed.
Exactly.
Okay. All right, another question. Thank you so much. That's great. And that's more of a comment. And there are chats. Let me just go onto the chat because people may have asked things under the chat group. Okay, I think the question one asked, I don't know in what context this was asked, but do you do individual inquiries or do you combine into one inquiry with one chairperson? I mean, it's quite difficult to answer that question without knowing the context. But I mean, there are a number of cases. Alan, do you want to comment on this? A number of cases I've worked with that deal with group inquiries and the circumstances under which you could provide a group inquiry.
One of the problems with with having a lot of fractured inquiries is, of course, having to leave the evidence again and again and again. So that's a very tedious process.
Well, it's not only a tedious process, but witnesses who've given evidence in previous cases and learned their mistakes can then correct those mistakes in subsequent cases.
So you might have different decisions coming out because the evidence in one case is found to be lacking in credibility, but was being fixed by the next case.
You've also got the problem of, you can't have a chairperson who's influenced by previous cases. So do you have a different chairperson who might assess the facts differently and come out with a different conclusion? Yeah.
So I think our view has always been that wherever possible, you find a way to have a single hearing.
If the facts are the same, it seems to us to make much more sense to have a group inquiry, where you allow individual representation on any circumstances or facts which may be different for each individual involved.
Yeah. I mean, the cost of going the other route, I think Takiso was faced with having to chair, like, I don't know, a number of inquiries into the same kind of offence where there'd been cheating of medical aid benefits. So each case was individual. It wasn't as if they did all the employees the same thing. They each had cheated medical aid in different ways.
So those individual facts had to be brought forward.
But Takiso was forced to use a number of their arbitrators to chair. Sometimes it can be very complicated. Yeah.
All right. The other comments that I'm seeing are just saying thank you and saying that it was extremely useful.
It does sound like you weren't very unclear, doesn't it, Bruce?
There's another question. There was a question about an external chairperson. I was wondering how they held the inquiry of the group. Okay, I think it's more of a comment. Okay, so thank you to all of you. We've been going for just almost an hour and a half. Thank you very much for having joined us. I hope you enjoyed it. I hope you found it worthwhile. And those of you who are not Workdoor subscribers, if you want to contact us, if you have an interest in subscribing to Workdoor, please do so, and we'd be glad to help you. Thank you. Thanks to Alan for coming up from Cape Town.
Pleasure.
And thanks for being with us.
Thanks.
Cheerio.